On behalf of my co-host and partner in organization, Father Greg Kalsher, I'd like to welcome you to this conference on the rule of law and the common good, and to thank all of you who have traveled to be here from as far away as Australia, as you'll see shortly, but as close as the dorm next door. You are all very welcome as we talk about this issue that has become, if possible, even more relevant than it was at the time that Father Kalsher and I thought about organizing this conference early last summer. So I'm going to turn it over to Father Kalsher, who will introduce our moderator and give you a little bit of sense of what's going on. And I hope you enjoy and are edified in equal parts by the talk this afternoon and by the reception to follow. Thank you.
Thanks very much, Kathy. Let me echo all your welcoming remarks. About a year ago, I was at a theology department event, and Kathy said something about the rule of law and can Catholic social thought somehow speak to this, and I said, we should do something about that. We should bring that into conversation, so that's brought us to this point. I want to thank all the people who have helped to bring us here. The sponsorship of this event has been under the guidance of the law school and the Morrissey College of Arts and Sciences, the Provost office, the Jesuit Institute, and a generous anonymous benefactor. So we're very happy to have been able to bring everybody together for this event. The moderator for this first panel is our Provost, David Quigley, and I will, I think, just quickly turn things over to him and let the conversation begin. So thank you, David.
Let me begin with sincere thanks to both Professor Keynote and Father Kalsher for all the work that they've done in pulling this together. As a 19th century U.S. historian, I know both the importance of this topic, the resources in the Catholic intellectual tradition that can be brought to bear on this topic, but also the fraught relationship between rule of law, Catholic social thinking at different moments in our nation's history, and I look forward to conversations over the next couple days. I should say that Professor Keynote in particular is a great bridge builder, moving between her appointments in law and theology, but we happen to have the oddity of a dean of our arts and sciences unit whose terminal degree is a JD, and our Dean of Law, who will be with us tomorrow, who has a PhD in government. So there's a lot of kind of bridge crossing that goes on campus, and I hope the conversations over the next 24 hours build on that spirit. We've got very clear orders from our organizers that we will not have extended introductions, even though our panelists certainly merit them in the program. You can see the distinguished backgrounds of all the presenters, so I'll give a very brief overview in just a moment of them so that we can get to their remarks as quickly as possible. I should note that as we go through the next hour and 45 minutes or so, we'll have until around 5:20 or so for the three panelists to offer their reflections and to help frame the conversations of the next day. And then we'll have an opportunity for some back and forth, some questions, some kind of elaboration between the three of them. Around 5:25, 5:30 or so, we'll turn to the tables, and I think this will be a feature of all the sessions between now and tomorrow afternoon, to give you 10 or 15 minutes to see what resonates, to see what kind of provokes and what questions you might have. And if all goes according to plan, by around 5:45, we'll have a concluding 10 or 15 minutes for questions from the audience, and I think our two co-organizers will have microphones coming around the room. But without any further ado, let me offer brief introductions and I guess one explanatory remark as to why I have an Australian to my side and not a Duke law professor. But we have three distinguished panelists. Purdy was not able to make the flight up from the Research Triangle earlier today and will be joining us tomorrow. So we have a slight change of plan, but I think still a rich set of framing remarks. Standing in very generously is Frank Brennan of the Society of Jesus, traveling to us from Brisbane, from the Australian Catholic University and the Australian Centre for Christianity and Culture. To his right, as you look to the front of the room, to his left, we have David Luban, university professor and professor of law and philosophy at Georgetown University. And then finally, to my far right, as you look up on the left, Marion O'Connell, Robert and Marion Short Professor of Law, as well as Professor of International Peace Studies at the Kroc Institute at the University of Notre Dame. And it is my great pleasure to ask Father Brennan to kick off our remarks with a first set of reflections.
Good afternoon, everyone, and thank you for that very gracious introduction. I'm very grateful to Professor Caveney and Father Kauschler for the invitation to fly across the Pacific and even further in order to be with you today. And having had the Gasson Chair in 2015, I'm very privileged to be here in Gasson Hall to offer some opening remarks. My key proposals will be that Catholic social thought supports the processes and structures for a rules-based order, nationally and internationally. That Catholic social thought espouses a rules-based order which includes substantive protection of human rights, that is, respect for human rights, non-discrimination and equality before the law. That Catholic social thought stands for the rule of law and not simply rule by law. And that Catholic social thought endorses the dual goal enunciated by Aziz Ranar in that huge book of his, which concludes with a call for meaningful freedom to all at home and actual self-determination for all abroad. In these opening remarks, I'll basically go through in this order. I'll say something about address by our recent popes to parliaments or congresses, outlining just very briefly some of the principles of Catholic social teaching in relation to the rule of law. Then, looking at defining the rule of law, I'll look at the differences between Lord Bingham on the one hand and Professor Raz on the other, and come down in support of the proposal put by the Venice Commission. I'll then look briefly at different modalities of the rule of law, insisting to you and an American audience that it's not necessarily ruled by judges, but that it's ruled by legislature, judiciary and executive. I'll then say a little about the role of judges in acute controversies, then open up the rule of law and war, on which of course Professor O'Connell will have much more to say. And then, with an Australian perspective, might I offer you some observations on middle powers in the time of the abandonment of the rule of law, and middle powers and restoring a rules-based order. And I'll conclude with what I think is a very distinctive Catholic contribution in many countries nowadays, that is, in trying to extend the rule of law not only to citizens, but to those who are non-citizens, particularly those who are asylum seekers or those seeking access to first world countries. So first, popes to parliaments. Pope Benedict had a very, very splendid address when he spoke to the parliamentarians at Westminster in London. He said, "Britain has emerged as a pluralist democracy which places great value on freedom of speech, freedom of political affiliation, and respect for the rule of law, with a strong sense of the individual's rights and duties and of the equality of all citizens before the law." In that same address, he said, "The Catholic tradition maintains that the objective norms governing right action are accessible to reason, prescinding from the content of revelation. According to this understanding, the role of religion in political debate is not so much to supply these norms, as if they could not be known by non-believers, still less to propose concrete political solutions, which would lie altogether outside the competence of religion, but rather to help purify and shed light upon the application of reason to the discovery of objective moral principles." So I think if by tomorrow we can say that we've helped purify and shed light on the application of reason to the discovery of objective moral principles, we'll have done well. Addressing the European Parliament in 2014, Pope Francis asked, "What dignity can there be without a clear juridical framework which limits the rule of force and enables the rule of law to prevail over the power of tyranny?" Well, I think it's a very timely question for us in 2026. You'll recall that when he addressed the US Congress, he used that old trick of his. He went in your door and drew you out his. He commenced, "I'm most grateful for your invitation to address this session of Congress in the land of the free and the home of the brave. I would like to think that the reason for this is that I too am a son of this great continent for which we have all received so much and towards which we share a common responsibility. You are called to defend and preserve the dignity of your fellow citizens in the tireless, demanding pursuit of the common good, for this is the chief aim of all politics." He went on to say, "If politics must truly be at the service of the human person, it follows it cannot be a slave to the economy and finance. Politics is instead an expression of our compelling need to live as one in order to build as one the greatest common good, that of a community which sacrifices particular interests in order to share in justice and peace its goods, its interests, and its social life." So, how do we define the rule of law? It's been prevalent in recent times to take as the starting point the very detailed work of Lord Thomas Bingham, who said, "All persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future and publicly administered in the courts." Now, Bingham proposed 8 ingredients for the rule of law. I won't take you through all 8, and many of you are familiar with those. But the 2 which are most contested are principles 5 and 8. He thought that a necessary ingredient of the rule of law was that the law must afford adequate protection of fundamental human rights. And furthermore, that the rule of law requires compliance by the state with its obligations in international law as in national law. Simon Lee, writing on Christianity and the rule of law in that splendid new book, the Oxford Handbook of Christianity and the Law, notes that Bingham's 5th and 8th principles go further than Raz does, taking his interpretation into the substance of the laws. Raz particularly questions the belief that the rule of law is particularly relevant to the protection of equality, and that equality is related to the generality of the law. Raz says this last belief is mistaken. He states, "Racial, religious, and all manner of discrimination are not only compatible, but often institutionalised by general rules." But there is a difference between the rule of law and rule by law. And I want to come back to that a couple of times in my presentation. One time, British Attorney General Lord Goldsmith said that the rule of law is not simply about rule by law. Such a proposition would be satisfied whatever the law and however unfair, unjust, or contrary to fundamental principles, provided only that it was applied to all. Instead, he says, it seems to me clear that the rule of law comprehends some statement of values which are universal and ought to be respected as the basis of a free society. I had the good fortune of having a father who was Chief Justice of Australia, so I take the liberty of quoting him. He said, "The rule of law implies that those who live under the law are living in a free and ordered society in which individual dignity is respected and all enjoy immunity from the exercise of arbitrary power or unjust discrimination. Each branch of government must play its part to effect that result," he said. Lord Goldsmith agrees. He says, "In my view, all the organs of the state, the executive, the legislature and the judiciary, have a shared responsibility for upholding the rule of law. This is not to downplay the responsibility of the courts. They provide the critical long-stop guarantee. But the rule of law will only have real meaning in practical terms in a society in which all organs of the state are mindful of their obligations to respect it." I think tomorrow's presenter, Aziz Rana, would support both the distinction between rule by law and rule of law, and Bingham's substantive additional ingredients to the rule of law. Including his massive tome, The Constitutional Bind, he asks, can members of a dominant imperial power truly choose to abandon the pillars of that power in favour of a transformed society? He answers that such a society would extend meaningful freedom to all at home and embrace actual self-determination for all abroad. So, having outlined something of the Bingham and Raz approaches to the rule of law, let me come to the Council of Europe's European Commission for Democracy Through Law, the Venice Commission, which adopted its report in 2011, which set out a contemporary working definition of the rule of law. The Commission proposed that a consensus can now be found for the necessary elements of the rule of law. They gave 6. 1, legality, including a transparent, accountable and democratic process for enacting law. 2, legal certainty. 3, prohibition of arbitrariness. 4, access to justice before independent and impartial courts. 5, respect for human rights. 6, non-discrimination and equality before the law. So you'll note that the Venice Commission has gone more with the Bingham approach rather than the Raz approach. In view of the definitions proposed by Bingham and the Venice Commission, I suggest that Catholic social thought can best contribute to legal theory on the rule of law when it comes to considering the law affording protection of human rights, non-discrimination and equality before the law, and compliance by the state with its obligations in international law as in national law. As Pope Benedict said at Westminster, we Catholics best do this by emphasising the unique dignity of every human person, created in the image and likeness of God, and the duty of civil authority to foster the common good. When considering the balance between human rights and the common good, I think nowadays it's become rather fashionable to overlook the actual wording of the UN Declaration of Human Rights. You'll recall that Article 29(2) states that in the exercise of his rights and freedoms, everyone shall be subject only to such limitations are determined by law solely for the purpose of securing due recognition and respect for the rights and freedoms of others and of meeting the just requirements of morality, public order, and the general welfare in a democratic society. I'd like to suggest that in Catholic discourse, we're more familiar nowadays than maybe the legal academy generally in talking about topics such as morality, public order, and the general welfare in democratic society. But I think they are constitutive elements of the common good. Recent popes have addressed Rana's challenge of providing meaningful freedom to all and embracing actual self-determination for all abroad. Think only of Pope Francis's encyclical Fratelli Tutti. Now, a word about different modalities of the rule of law. In 1995, I had the privilege of having a Fulbright at Georgetown Law Centre. As David would know, one of the great things about Georgetown is location, location and location. And in those days, even a foreigner like me had access to the Supreme Court to go and listen to arguments. But I also had the fortune of having the name Brennan, which meant I befriended your Justice Brennan. And so in the end, I wrote a book called Legislating Liberty, but I dedicated it in these terms: to the late Justice William Brennan, who inspired me in his judicial espousal of human rights without altogether converting me to the constitutional entrenchment of such rights. It seems to me that there are different models for each branch of government playing its role. And if we are talking about the rule of law and not simply rule by law, the rule of law does not equate with rule by judges, nor with rule of judges. It includes rule by and of the legislature, the executive and the judiciary. When I was here in 1995 and then following up in 96 and 97, the key issues being debated in both societies, Australia and the United States, were abortion and euthanasia. Basically, the outcomes, socially and politically, were much the same, except that they were far more contested here. But the abortion rates in both countries were the same. And when it came to the issue, the crunch point here in the United States was, how do 9 unelected judges make these decisions? Whereas in Australia, it was left up to duly elected parliaments to make those decisions. So at the very same time that the US Supreme Court was striking down unanimously any proposal for physician-assisted dying, such a proposal was struck down by the Australian Senate, but I think by a vote of 35 to 33. And I think the public debate in the Australian Senate, with the possibility of anybody and everybody making submissions to the Senate and the duly elected representatives making the decisions, I think that was a more coherent outcome than that of your Supreme Court. Perhaps to upset you, I'll just read a couple of the paragraphs with which I concluded the book. The Australian garden of rights and freedom should continue to be pruned and fertilised by our judges and legislators playing their respective roles with an eye to the outcome in the United States. I see no benefit in excluding the legislators from the garden and in creating a monopoly for the judges. Judges alone are unlikely to satisfy the people that the right balance is struck in times of rapid change in the multicultural, increasingly globalised garden, cross-fertilised by seeds and pollens for every value system on earth. Our elected representatives must remain the custodians of the common good and not simply the readers of the opinion polls, lest our judges be cast as philosopher kings of a Platonic bent as they are expected to be in the United States. I concluded, there's no need for our judges to be the exclusive arbiters of due process and equal protection. Their American brethren, armed with their highly developed jurisprudence and the democratic legitimacy of Senate confirmation hearings, demonstrate time and again that one judge's animosity is simply another judge's rationality. Now, I should point out I wrote this 30 years before Justice Kavanaugh and Jackson had their recent discussion. We can import their rationality second-hand without having to infect our own benches with the animosity inculcated by unelected judges trying to develop a judicial method for anti-majoritarian policy decisions benefiting those whose interests who have never known special protection in the past. In Australia, the pace of change and the balancing of rights and the public interest should still lie principally with the people through their elected representatives, while the judges maintain the rule of law and avoid politics smuggled into law. In conclusion, to say a little about international law and the role that might be played there in terms of the rule of law. You will be aware that yesterday or today in the New York Times, there have been observations made about the need for moral language which can act as a psychological scaffolding for service members when they are committed to war. And when that disappears, it can leave troops carrying the moral burden alone. And I can tell you from experience on the back end, it doesn't feel very good to have participated in a war that everybody thinks was a disaster. Now, the contribution of Catholic social teaching, we've had our Cardinal Secretary, Cardinal Parolin, state, if states were to be recognised as having a right to preventive war according to their own criteria and without a supranational legal framework, the whole world would risk being set ablaze. This erosion of international law is truly worrying. Justice has given way to force. The force of law has been replaced by the law of force and the conviction that peace can arise only after the enemy has been annihilated. And Cardinal McElroy, Archbishop of Washington, has been very definitive. At this present moment, the US decision to go to war against Iran fails to meet the just war threshold for a morally legitimate war. One thing that happens when the rule of law is abandoned completely by decision makers in the hegemon is that those of us who live in middle power countries are left somewhat bereft. We've had the absurd situation in the last week in Australia where our Prime Minister, who's left of centre, of a left of centre Labor Party, has of course endorsed the war, but when quizzed by journalists has said, now, we are not in a position to determine the legal basis of decisions that the United States and Israel have made, which is why we've said that is a matter for them to determine. But what we can do is make a judgment about what is in our national interests and what we support in order to keep Australia safe. So if there be no commitment to any rule of law, then I think it just comes down to might is right and to basic self-interest. You'll be aware that the Prime Minister of the country adjacent to here, Mark Carney, has been travelling the globe, putting a theory about how middle powers might contribute to restoring the rules-based order. He spoke to the Australian Parliament last week and said, in the new global environment, the ability to form effective coalitions is becoming a central strategic capability. Great powers can compel, but compulsion comes with costs, both reputational and financial. Middle powers can convene, but not everyone can. He said middle powers, like Australia and Canada, hold this rare convening power because others know we mean what we say and we will match our values with our actions. In other words, there's a place for middle powers committed to the rule of law and the common good when major powers act arbitrarily, asserting that might is right. And finally, the distinctive Catholic contribution on matters to do with immigration and the rule of law. You'll recall that your own bishops last November issued a strong statement saying that Catholic teaching exhorts nations to recognise the fundamental dignity of all persons, including immigrants. We recognise that nations have a responsibility to regulate their borders and establish a just and orderly immigration system for the sake of the common good. In my own country, constant abuse of parliamentary process in passing laws designed to ensure that asylum seekers cannot reach our shores and that courts cannot get near the decision makers are the order of the day. We've had the absurd situation in recent days. Mr. Trump rang our Prime Minister at 1 a.m. and spoke for 40 minutes, pleading passionately for the Iranian soccer players who are in Australia that they be given asylum, and they were offered asylum. The next day, the Australian Parliament passed a law which would allow the minister to make a declaration that even though visas had been issued to people from particular countries, that those visas would now be automatically suspended. That law applies to no less than 7,200 Iranians who presently have visas to come to Australia, but their visas have now been suspended permanently. It's in that space where our governments, our parliaments, our congresses take the view that non-citizens are not to be extended the rule of law, even in relation to the most fundamental of human rights, that I think Catholic social thought is able to support the processes and structures for a rules-based order, both nationally and internationally. So to conclude, Catholic social thought espouses a rules-based order which includes substantive protection of human rights, that is, respect for human rights, non-discrimination and equality before the law. Catholic social thought stands for the rule of law and not simply rule by law. And Catholic social thought endorses that dual goal enunciated by Aziz Rana of meaningful freedom to all at home and actual self-determination for all abroad. Thank you.
Thank you very much, Father Brendan, for getting us started. And now it's my pleasure to ask Professor Luban to take the microphone.
Hello, it's really a great pleasure to be here. This semester I'm teaching legal ethics. Last semester I taught a seminar called The Law Under Stress, about the role of lawyers in current crises in the rule of law. And that means that I've had to read through an enormous amount of dreck. Court orders, opinions, briefs, disciplinary complaints, and I just want to start off with a couple of examples about what I think of as misbehaving lawyers. So government prosecutions or attempted prosecutions of the president's personal enemies, executive orders against law firms because they committed the sin of hiring a lawyer who once represented the president's personal enemies, widespread defiance of court orders. Those of you who've been following the action in Minnesota will know that a couple of weeks ago, the Chief District Judge, Patrick Schultz, did a count and found that in the last 3 months, the Justice Department has defied 210 court orders in 174 different cases, which he says is more examples of the government defying court orders than all the government agencies put together, possibly in the entire history of the Republic. Attacks on judges, calling them rogues, a suit by the Justice Department against the entire 15 judges on the Maryland District Court. Why? Because they had put a 48-hour stay on summary deportation so that removed persons could have habeas hearings. A vindictive and completely frivolous ethics complaint against the chief judge in the District of Columbia, Judge Boasberg, which was rather summarily dismissed, basically in revenge for the fact that he wanted to have a contempt hearing for government lawyers who had lied to him. The firing, driving away of government lawyers who want to maintain the minimum norms of impartiality and ethics, and all of this is accompanied by the rhetorical strategy that scholars call accusation in mirror, and that is, if you are accused of a crime, you just accuse your accuser of exactly the same crime. So what we've seen is not only does the Justice Department repeatedly refer to the judges as rogue judges, activist judges, left-wing lunatic judges, but it accuses those judges and the honest government lawyers of being the real enemies of the rule of law. So one of the conclusions is that the rule of law in the U.S. at the moment is under attack by its own government. To me, the thing that's really striking about this as a legal ethics teacher is that it's lawyers who are the shock troops in this attack. And so the questions that I want to talk about today are these. Is there anything wrong about lawyers when they make themselves the engines of rule of law backsliding? And another question that's connected with that, is kind of the flip side, is do lawyers, because they're lawyers, have any kind of special obligation over and above other citizens to uphold and maintain the rule of law? Now, some might say no. That's the answer to your questions is no. On our standard conception of legal ethics, a lawyer can represent any client for any end. I mean, kind of, baked into the fundamental ethics of the profession is a kind of studied agnosticism or relativism about client ends, and the profession is proud of that, and not without reason, because it guarantees that, that kind of agnosticism means that really unpopular people can still have their rights defended by lawyers. Nevertheless, it is a kind of agnosticism about the goodness of client ends. And that would include, on that standard model, clients whose end is to undermine the impartial rule of law using facially legal means. And that's what I'll call a rule of law backsliding. It's closely connected to something that observers all over the world are talking about, democratic backsliding. My colleague and co-author, Scott Cummings at UCLA Law School, has written a couple of fantastic articles about the role of lawyers in democratic backsliding. And one, his latest, called The Autocratic Legal Playbook. Now, you might think that this standard model that I've just described it shouldn't apply to lawyers in the executive branch of government, that maybe they have a higher vocation, and you might think there is a constitutional basis for that. The president has an obligation to take care that the laws are faithfully executed. But the legal theory that I think the Supreme Court has mistakenly taken is that take care clause is not a presidential obligation that can be enforced by anyone else, but rather a preclusive presidential permission to make sure that everybody who works for the president is taking care that the laws are executed faithful to the president's own will. Now, that means essentially treating the President of the United States as something like a private client, and I think making the legal, conceptual, and philosophical mistake of identifying the person and the office. But given that that's so, this question, is there anything wrong with lawyers engaging in making themselves engines of rule of law backsliding, is a real one. Now, 50 years ago, Charles Freed, who the late Harvard law professor and Solicitor General of the United States, wrote a great article called The Lawyer's Friend. And in that article, he said, well, the answer is no. And I'm just going to quote a few lines. Some of the more ecstatic critics have put forward the lawyer as some kind of anointed priest of justice. But this is wrong. In a democratic society, justice has no anointed priests. The lawyer has no special moral responsibilities in that regard. Now, I agree with Charles Freed that lawyers are not anointed priests of justice. But I'm going to defend a different model and a different metaphor, and that is that lawyers are trustees of the rule of law, and as such, they have a trustee's fiduciary obligation to uphold the law and not to tear it down. Now, that sounds maybe a little bit oracular and cryptic. My task in the few minutes here is to explain and defend this trusteeship model. And I'm going to point out that it harmonizes with the theme of this conference because the defense is grounded in a certain conception of the common good. So let me just start with some very, very rough and definitions of the two terms here, rule of law and common good. So there are a lot of theories in the philosophical literature about what the rule of law is, and you can think of it in the very thinnest terms as something like what law students call procedural due process. You can understand it in a thicker way by including whatever the conditions are needed in order for law to guide human action. This is the view of Lon Fuller in his famous canons, that the law has to be something people can understand. It has to be something people are capable of following. So otherwise it can't guide human actions, and the whole enterprise of law falls Or you can define it in a thicker way still as requiring impartial institutions of policing and law enforcement and judging in order to make sure that the law on the books is congruent with the law in action, Joseph Raz's view. Or you can define it thicker still, as Jerry Postema has in his fantastic book on laws and rule, it's about the protection of people against arbitrary power. Now, I'm going to go with all four of these and therefore take a thick conception of the rule of law, but I think that there's an even more basic idea. That phrase, rule of law, is lopped off from a longer phrase, the rule of law, not of men. A phrase used by Plato in the Laws, by Aristotle in the Politics, by John Adams, and of course by John Marshall in Marbury versus Madison. So I'm going to say that in addition, you have to understand the rule of law as an attempt to institutionalize anti-autocracy. The opposite of the rule of law is autocratic rule here. That's all I'm going to say about the rule of law. Now, the common good, I'm going to give a sort of, how to put it, non-denominational view. When I got to Georgetown, I'm a Jewish guy, and I was starting to teach in a Catholic law school, and I went over to one of my Jesuit colleagues, Father Bob Drinan, who is one of the greats. He was the dean of this law school for 14 years, and then a very distinguished United States congressman before he came to Georgetown Law. And I said, well, Father Drinan, what is the Catholic social teaching? And he just kind of grinned at me. And he said, well, it's just what the rabbi said. It's tikkun olam, heal the world. And this kind of fortified me into thinking that there is such a thing as a small c Catholic social teaching, and it's grounded in something that my own Jewish tradition and the Catholic tradition share, which is a respect for basic human dignity. As the rabbis say in the Talmud, respecting human dignity is more important than following the laws of the Torah. Let's get more concrete about this. How is the common good institutionalized in the United States? Well, look at the preamble to the Constitution. First of all, it says that we're established by we the people, viewed collectively. And one of the things about we the people is that means all of us, the people, not some of us, but not you guys. Now, what do we the people do? We ordain a constitution to promote general welfare. And I think that there's semantic distinctions that are important, but general welfare and the common good overlap. What are the components of it? Well, in the Constitution, it's justice and tranquility and common defense. For those of you who've read Professor Vermeule's book on common good constitutionalism, you'll know that he adds a few other things, health and safety, economic security, and one that I think is very important, solidarity. Meaning, once again, that we the people is not just some of the people. Now, I'm attracted to a particular version of what this means in a democracy, and it's something that, and this is not a phrase original to me, is a theory of democratic self-authorship. And what this means is roughly the view that it's we the people and not our elected representatives who are the true authors of the law. And we the people create our laws for the benefit of, guess who? We the people. We the people are at once the producers of law, and we are the beneficiaries of law. Now, interestingly, the democratic self-authorship theory originates in debates about statutory interpretation, where there's a received view that judges who are interpreting statutes should be faithful agents of the legislature. Not so, says Justice Barrett. They should be faithful agents of, guess who? We the people. Other legal theorists, Paul Kahn and Kyle Brennan Marquez, say that what democratic self-authorship means is also that we the people are accountable for the laws that we enact. And that has implications for how you read statutes. I'm going to call the solidarity canon of interpretation. You have to read statutes that are ambiguous in a way that tries not to use the technical legal term, screw over the human dignity of anybody. Now, I don't want to get sidetracked into the theory of statutory interpretation. What I'm taking from this is the idea that we the people collectively create law to enhance the common good, the general welfare of we the people. Now, you might say this is a legal fiction, but if it is nothing more than a fantasy, then the whole idea of the common good is also a fantasy, and the Constitution is a fantasy. And popular sovereignty is a fantasy, and lawyers are simply playing fantasy law, force masquerading as law. This is where the role of lawyers comes in. Law is complicated, and there are very good reasons why the law has to be complicated, too complicated for people who aren't trained in the law to actually negotiate the rights and remedies that it creates. And that makes lawyers the licensed gatekeepers standing at the gate of the law's remedies. We've made the law in order to make the lawyers indispensable. And here's where the idea of trusteeship comes in. So let's just think abstractly. Trusteeship is a model where there's one party, in legalese, the settlor, who has some kind of an asset or good that they want administered for the benefit of another party, the beneficiary. Parents establish a trust for a minor child. A trustee is the person that's chosen to administer that and has a fiduciary obligation not to put self-interest or any other interest in front of the obligation to the beneficiary. Now, if you think of the law as a good that we the people, the settlers, create for the benefit of we the people, the beneficiary, guess who the trustee is? It is the legal profession. And as such, I think that lawyers have a duty to ensure that those laws are enforced for the common good of the beneficiary. I'm going to say it again, we the people. That's what the rule of law is. And upholding it is a lawyerly duty that I think goes beyond lawyers' duty to their clients. Now, one corollary you might draw has to do with the access to justice debate. Lawyers should have a duty to make sure that people who can't afford legal services have access to it. That's not what I want to talk about today. Today, what I'm talking about is a different corollary, that lawyers who sabotage the rule of law are betraying their trust. Now, it may be that some of the lawyers who are engaged in as engines of attacking the rule of law are by political conviction anti-liberals, and they may see themselves as heroes of the fourth turning who are using the master's rules to destroy the master's house, or if I could use a biblical metaphor, Samson pulling down the temple of the woke Philistines. I see them as Wile E. Coyote sitting on a branch and sawing off his own branch, because actually the rule of law is the condition of the possibility of the legal profession. Now, I'll say just a few more words. The problem is that the standard conception of lawyers' ethics that I've described doesn't leave much room for this way of thinking. Of course, you can find plenty of rhetoric. If you look at the preamble to the Model Rules of Professional Conduct, it says that a lawyer is a public citizen having special responsibilities for the quality of justice. But this is non-binding, and I think it's more rhetoric than reality. The substance of the rules is built around a model of representing client interests without thinking about the quality of justice, and being agnostic about the client ends. And guess what? As a lawyer, I am not morally accountable for my client's ends. In fact, if I'm thinking too much about the quality of justice, that's a conflict of interest, and I ought to remove myself from the case. So to conclude, what I'm calling for is a rethinking of what it means to be a good lawyer, and especially a good government lawyer. First, to understand that the rule of law is part of the common good. It's not a roadblock in the way of the executive imposing a vision of the common good. Second, lawyers are morally accountable for the causes they represent in the root sense that, those of you who've read Brad Wendel's fantastic new book, Canceling Lawyers, accountability doesn't mean tort liability. It means you owe an account. You need to give reasons that are acceptable to other people. Third, that lawyers have a special obligation to uphold the impartial rule of law, not because lawyers are high priests of justice, but because they are trustees of we the people. Fourth, that obligation goes beyond the positive law that you find in the rules of professional conduct and the law of lawyering. Beyond it, but it's also the very foundation for the legal profession. Fifth, government lawyers inherit the president's constitutional obligation to take care that the laws are faithfully executed, and I want to put a lot of stress on the word faithfully there. Because sixth, faithfully means following the laws, not the man in charge. So this is going all the way back to Plato. Plato wrote in the laws that the gods will smile on the city where the laws rule the rulers, and the rulers are servants of the law. And that's thank you.
Thank you. And now to have the third of our panelists, I'd ask Professor O'Connell to come forward.
I'm Irish, so I have to keep some track of the time, or we'll be here till tomorrow morning. And it is a real honor to be with all of you and to have heard from my two colleagues and to try to add yet another dimension to this rich conversation. And I have to go back to just a few weeks ago. On the morning of February 28th, 2026, Israel and the United States launched a war on Iran. Within days, nearly 1,000 people were dead, the level of destruction unknown. The United Nations Charter prohibits the resort to military force unless justified by self-defense under strict conditions not met by the US and Israel or with UN Security Council authorization, also missing. Just weeks before, following the US attacks on Venezuela, Pope Leo had spoken to ambassadors from 184 countries, condemning the fact that, quote, war is back in vogue, and a zeal for war is spreading. Peace is no longer sought as a gift and a desirable good in itself. This gravely threatens the rule of law, which is at the foundation of all peaceful coexistence. Pope Leo is right to raise concern about the zeal for war and its negative impact on the rule of law. In October 2025, the World Justice Project reported that the rule of law had declined globally for the 8th year in a row. The very topic of this conference reflects the reality. Pope Leo, however, focused on only one of the two attitudes that I see as contributing to this decline. He focused on the zeal for war, but there's also a zeal for wealth. And we can see in Pope in President Trump a model of both of these zeals. We know about his profit-seeking with little or no regard for the law or ethical standards that governs accumulation. We've also seen in the past year that he has ordered continuing unlawful attacks on Somalia, Yemen, Iran in June and February, in the Caribbean, in the Pacific, on Syria, on Nigeria on Christmas Day after Pope Leo called for a day of ceasefire. And on January 3rd, he ordered airstrikes and special operations forces against Venezuela. I cannot tell you how many people have died in this last year through these unlawful uses of force and how much of the built and natural environment has been devastated. I can tell you that the law against these violent actions has been steadily dishonored in this country since the end of the Cold War. Presidents have interpreted the law as allowing more and more exceptions, to the point that President Trump apparently can no longer see any legal obstacles to his will to use force. And we can understand where he's coming from. So we're in a dark place. But unlike other discussions of the declining rule of law, which are very much in vogue, this conference is about more than just decline. It is also about Catholic social teaching, CST. It is about a problem and a response. We are invited to consider it an almost unparalleled resource for addressing exactly the sort of social ill we now confront. Lost respect for the law against war and the law against certain means of acquiring wealth. The evidence of declining respect for law is ample. In my own field of international law, when Russia perpetrated its full-scale invasion of Ukraine in February 2022, almost a third of the members of the United Nations General Assembly refused to condemn the invasion. A common explanation at the time was that these states were done with the double standard that allowed the United States and its allies to put a flimsy legal justification over massive violations and avoid condemnation, holding Russia to the authentic legal standard while giving the West a pass. Apparently that means for some that international law is dead, for all of us. As President Trump looked set to order the United States military to seize Greenland from NATO ally Denmark in January, world leaders, including Canada's Prime Minister and Germany's Chancellor, concluded that the international rules-based order is dead. In fact, ladies and gentlemen, the rules-based order is not over because there never was a rules-based order in the way that Prime Minister Carney meant it. There is and always will be an international legal order. The enduring features of that order apply to all law, regardless of category, local, national, regional, or international. The law itself, its fundamental features, and its highest normative principles endure so long as people seek to live in community. The challenge we face today, which has been identified as the declining rule of law, is something else. We are seeing a crisis in law compliance. In my view, the crisis is related to two basic misunderstandings. First, people misunderstanding legal fundamentals, aspects of the nature of law, what law is for, what rules and principles are subject to termination, and what law endures. Second, and relatedly, people are losing sight of the reason to comply with law. CST provides answers to all these questions. But for decades, government officials, scholars, and advocates have looked away from these answers to false ones that have helped land us where we are today. Law and political science are dominated by so-called realist theories. These are narrowly materialist ideologies that rely on the human inclination to wealth maximization and to security on the basis of physical strength. They draw on the human tendency to be influenced by greed and fear. Law, however, cannot rest on such an understanding of humanity. Law essentially rests on the human capacity for altruism. People can do things because it is the right thing to do, even where they do not benefit personally. Individuals and whole societies have engaged in acts of extraordinary generosity and nonviolence. Willingness to comply with the law solely to ensure peace and the common good. These are essential attitudes for law's success. My argument today is that people can be won back to these attitudes by thinking in a new way about the ancient insights upon which modern law is based. CST is drawn from those insights and has been constantly updated, as the Compendium of Catholic Social Teaching clearly shows. CST is an extraordinary resource to counter the law-undermining ideologies that dominate us today. It will take courage to speak, teach, and write against the dominant realist thinking. It will take creativity to present ancient ideas in a way that attract new adherents. I'm going to offer one strategy today for doing so, and that is to let go of the focus on what is wrong with the dominant ideologies and to speak instead of what is right about authentic law and the thinking that supports it, such as CST. I will strive to do so here in my very short time by developing 3 points. First, to look to CST and its rationale for why the law is a good and for its fundamental purpose of promoting peace. In other words, why should we bother worrying so much about this? Second, the second point considers the ideologies that are obscuring these core truths. Realist thinking, that human beings are dominated by the search for wealth and physical security. And the third point takes up this idea of how to attract scholars, government officials, and advocates to the CST orientation to the law. I'm going to suggest yet another understanding of the rule of law to the two we've already had, and that is simply that the law is a superior form of binding standard in the relations of peoples and communities. Law, with all due respect to the two previous speakers, does not need government. It does not need democracy. What law needs is acknowledgement or recognition, and international law is the proof of that. It exists without government. It is not part of a democracy. CST supports recognition of law's place in human relations. It does so by presenting the law as a good. 2 reasons stand out to me as to why law is a good, drawing on CST, and why the decline of the rule of law should be countered. Law's major purpose is the preservation of peace. Pope Leo said in that same address to ambassadors on January 9th, as Augustine reminds us, peace is the aim of our good. In addition, as Kathy Caveney has written, Aquinas taught that compliance with law promotes the moral virtue of women and men by involving them in the pursuit of the common good. Indeed, the earliest evidence of law that we have from legal historians and anthropologists is that law came into communities for the peaceful settlement of disputes. Law has been defined as the concrete expression of transcendent norms. Law is an idea, a feature of social life. It has evolved to become a complex, intricate aspect of human culture and normative social practice, providing an alternative to physical force and religion for establishing order among social groups. While law provides this alternative, it also incorporates aspects, of course, of both force and religion. Religion and philosophical teaching is seen in the description of law's purpose as actualizing peaceful social order, and law over a certain amount of coercion to signal that rules are binding is how force also comes into the bigger construct of law. These ideas emerged in 2 aspects, natural law and positive law. Legal principles of both types are essential to restraining the human tendencies to perpetrate violence and war and to disregard other people's needs in the pursuit of wealth. In a word, law needs to respond to people's innate selfishness. Law does so with restraints that aim at peace and the welfare of others, with the understanding that people are capable of generosity, even the generosity of pure altruism. Law needs altruism to work. People need to comply with the law even when they do not benefit. The crisis of law today is really about unwillingness to sacrifice for the good of others and complying with the law when force or money can apparently get a person what she wants without sacrifice. As I'll discuss in a brief moment here, realist ideologies reject the human capacity for altruism. By contrast, Jesus Christ, Thomas Aquinas, contemporary philosophers, especially of aesthetic philosophy, and anthropologists have all shown that selflessness is as inherent to humanity as self-interest. Our capacity for selflessness is a counterpoint to interest in self, providing an argument for law compliance even in the absence of personal advantage or coercion. We have a lot of these insights from the Roman Stoic and jurist Cicero, who of course was highly influential in Aquinas' thinking. He identified both the positive law aspects and that come through voluntary action, as well as the natural law norms that are discerned through observation of nature and openness to inspiration from transcendent sources. These sources are essential to authentic natural law because they help provide a source outside the internal discerner's own reasoning, a source of objectivity to control or counter the perhaps overly subjective view of the person doing the discerning. Cicero taught that certain norms of natural law endure even when violated. These are also the principles and precepts superior to or essential to the positive law. The discernment of transcendent norms occurs through human reasoning process, incorporating non-material sources of knowledge. Natural law and positive law require the application of human reason, but to different phenomena. The scholar or judge seeking to discern the enduring, moral, and perceptual components of law seeks inspiration from the natural world, revelation, scripture, emotion. The pleasure experienced in the perfectly proportional seascape or sunset has led to the understanding that legal principles must incorporate proportionality, equality, fairness. These are essential to law. The method is essential to law. And over centuries, such discernment has revealed the necessity of law derived from natural law methodology for a peaceful world. Positive law relies on reasoning about material facts, and it requires consent. Natural law is not formed through positive material acts and does not require consent. Natural law is also the path through which moral limits are placed on the positive law. Positive law has no inherent screening standard for content. So long as a rule comes through the legislature in the normal fashion, it is a law. The most important moral limits are found in the natural law. It's natural law that undergirds the jus cogens or peremptory norms, including the prohibitions on the use of force, on slavery, torture, genocide, apartheid, colonialism, and war crimes. These prohibitions never decline. They may expand, but they do not shrink, and they never disappear. New exceptions, for example, to the prohibition on the use of force are impossible. You cannot create new reasons why it's okay to go to war and to kill people because they're in some new category you've made up yesterday. We can extend the prohibition to areas where we had not discerned that it applies in the past. Evidence that I'm working with right now, a better understanding of the writings of Aquinas, suggests that the prohibition on force bans resort to civil war, not just intercommunal war. These are all necessary norms, explainable only in natural law theory. The rule of law has declined as we have been discussing it, in part because we've lost our understanding of the normative context and method of discernment of the natural law. When natural law method began to be challenged as early as the 18th century through scientific thinking, incorporation of transcendent inspiration was suppressed. Today, even scholars who identify themselves as natural law theorists often employ a variation on positivist method. The German Catholic international lawyer Christian Walter explains that gradually elements of divine revelation were replaced by reference to reason or the nature of things. A division developed between Naturrecht and Vernunftrecht. In English, we do not have two terms for natural law, and this has been part of the confusion in the Western literature. We use natural law for both types of discernment. John Finnis's work, for example, is an example of Vernunftrecht, not authentic Naturrecht. He has removed the contemplation of transcendent sources from his way of viewing what is natural law. There have been, and even John Finnis's contemporaries continued with Naturrecht, with classical natural law, including the great international lawyer of the University of Vienna, Alfred Verdross, a student of Hans Kelsen, and International Court of Justice judges, Tanaka from Japan, Viramonti from Sri Lanka, and Cansado Trindade from Brazil. So CST exists as a dynamic source of support for the rule of law for purposes of peace and the common good, and law that endures on the basis of authentic natural laws, holistic understanding of the meaning of law. Scholars have continued to teach and research on this basis, and judges have continued to judge. So I'm going to go back a little bit because I had a question during, let's call it the break. To restate the two German terms, they are essential to this story. So the two terms are Naturrecht and Vernunftrecht. One, we would translate in English we translate them both as natural law, but only the first, Naturrecht, should be translated as natural law. The other is reasonableness or legal rationality. I mentioned that in one of my many conversations with John Finnis, he said he would have preferred to call his book, which is titled Natural Law, Natural Right, Legal Reasonableness. But legal reasonableness, as I said, is a species of positivism. It cuts off inspiration from the transcendent sources of knowledge. And that is why we need more than the reasonableness approach to law, which of course is part of positive law. We do use reason, but we need much more. We cannot base, for example, consent that is the basis of positivism, on consent. We need something outside consent. So how did we get so off track? How did we remove true and authentic and preordinate natural law and reduce ourselves down to positive law alone? And I think it has to do with the dominance of realist thinking in political science in particular, but how that has come to affect law. And that, there's one person we can really look to who developed these ideas. I mean, Machiavelli plays a role, of course, in the thinking, but it's really Thomas Hobbes who has the real impact on how we think about law today, how we think about our relationships with one another in society under government. He was a 17th century British political theorist. He was terrified. He had lived through the trauma of the English Civil War, through that chaos, through the violence. He blamed the Catholic Church for that in large part, and he blamed the insufficient coercion of a strong central government. He hated the Catholic Church for other reasons, for its promotion of universal norms, the universal idea such as equality of all humanity. Hobbes wanted a strong little England, and he saw outside a place with a strong government coercing people into compliance with the law, a war of all against all. In his mind, it was anarchy outside a place where there's a strong, punishing state. Hobbes had some followers who added to these ideas in a way that kept it going beyond what you would have thought we might have rejected, these kinds of quite negative understandings. Hobbes really preached that human beings are not capable of complying with law out of goodness and altruism. They have to be forced into it through coercion, or they will only act in their self-interest. One of his major followers was John Locke. And Locke came up with the idea of a constitution with some limits on how punishing a government can be, so that people could live with government under constitution, and that constitution would still allow a great deal of coercion against individuals to get them to comply with the law. Two other followers of Hobbes were David Hume and Adam Smith. Yes, that Adam Smith. And Hume and Smith really also believed that a person's will is oriented naturally to act in her own self-interest in the face of scarcity. And thus law needs to be based on self-interest if we're ever going to attract voluntary obedience. 2 centuries later, largely thanks to work at the University of Chicago, these ideas from Hume and Smith and Hobbes and Locke become a whole way of looking at the law and economics. Law and economics is pursued on every major American law faculty, and natural law is not. It's been a complete flip. Whereas once every lawyer was trained in the natural law, in this country, almost none. If they are, it's in the finis mode. And then also, they are trained in law and economics, that law has to follow people's economic interests. So we're left with a theory that actually has no explanation for the binding power of promise, of consent. The law and economic theorists tell us that you can break your promise if you can pay somebody off. If you make more money breaking your promise than keeping it, so-called efficient breach, then you can breach it. Well, where does that leave promise as the basis of all positive law? Everything's transactional. If you don't get something for it, don't do it. In the parallel area governing the use of force, promises made in treaties to forego force in favor of peaceful settlement of disputes have been equally diluted to nothing through claims respecting the practice of powerful military states as alone being able to change the law, even their violations. Change would be a violation to compliance with a new rule made up through the violation. I kid you not, it has become that bad. U.S. government lawyers have introduced one interpretation after another that have increasingly diluted the prohibition on the use of force to virtually nothing beyond what the president says, and that's, of course, where we are today. Hans Morgenthau built on Hobbes's views. He helped promote these ideas with regard to diluting any obstacles to using military force. He was the great proponent of seeking hegemony through military force, that if you have the most physical power, just as the economists were telling us, if you have the most wealth, you can dictate. I think it's interesting that in Vincent Rougeau's book on Catholic social teaching, he points to the University of Chicago as being the place where the economic ideas of Milton Friedman challenged our ideas in Catholic social teaching of the common good. That's also where Hans Morgenthau challenged Catholic social teaching on peace, that only seeking military force, more assets, more capability is the only way to be secure. But this is the real point. Morgenthau, like Friedman, is read by everyone in the field. There's not a political scientist in this country that has not read Politics Among Nations. I think there are fewer theologians who read the Bible than political scientists who read Politics Among Nations. And these materialist ideas have undermined the good that Catholic social teaching tells us to seek through law, peace, and the good of the other. So at this point in time, it would be reasonable to predict that we are in such a negative, dark place, the world will turn back to natural law. We were in an even darker place, and we did this once before, despite the influence of Hobbes and his successors, and that was at the end of the Second World War. There was a return in law by theorists in Western Europe, in the United States, around the world, to natural law. We might think that we're at that point again. After all, Pope Francis told us that we are in piecemeal World War III. Perhaps in 3 years, when there's a new president of the United States, people will feel that that war is over and we need to return to the common good. That these ideas, that the negative impact of realism is great enough to motivate radical change. Well, conferences like this one are evidence that we are seeking new ways, new thinking, that there are real efforts of great creativity in law, philosophy, and theology. But a number of differences from the last period are evident, and one major concern that I want us to avoid if we can make this new start. At the end of World War II, continental Europeans had no choice but to think in a new way. Their universities were crushed. Their colleagues were dead or had fled. Moreover, they still had a tradition of natural law that they still carried with them, and humane philosophy. And there was no well-developed material theories of law and economics and of realism and political science to draw on. Even then, their new thinking, an answer to this catastrophe of the war, which had positive influences, that's the underlying rationale of the United Nations Charter and the Universal Declaration of Human Rights. That influence and that way of thinking lasted less than 10 years. And then the realist ideas were on overdrive. They were taking over. It took a while, but they triumphed by the end of the Cold War, when the US could say we reached hegemony through realism. And now, of course, as I said at the beginning, we've landed here. So I'm going to say very briefly, and hopefully there'll be more time to develop this in questions and answer, how we might respond to this moment, recapture some of the reasons why people went back to natural law after the Second World War, real natural law, but also how to avoid the failure to keep that momentum alive for only 10 years. I'm going to talk first, maybe two changes very briefly. First about style, and second about substance. Lawyers in the United States are trained in the adversarial process. Instead of attracting willing adherents to our ideas, we argue that our ideas are right and yours are wrong, and we put people on the defensive. This is really a fraught moment to put people on the defensive, that they go back and try to justify their reasons for going to war, because in this moment, the other dominant idea is accountability. One of the one of the few places where American international lawyers are still actively involved is international criminal courts. They want to see people put on trial. And some of them know that after the Second World War at Nuremberg, lawyers were put on trial for coming up with false assessments of the law of self-defense. Ribbentrop was sentenced and punished because of his self-defense arguments that Germany needed to preemptively attack Norway and the Low Countries in self-defense. And he was found guilty for that wrong legal advice that led to a crime against the peace. So if you overemphasize accountability, people have to defend their ground, especially in a time of we want to put, you are the war criminals, no, you are the war criminals, and that's how we negatively go around. I talk all the time. I have taught in Ukraine during the war, and my colleagues and friends and students there all just want to talk about putting Vladimir Putin on trial. They do not want to talk about how we inculcate a norm of peace again so that future Putins will find it beyond the pale to do what Putin felt by 2022, that there just were no obstacles to that, the most serious violation of the UN Charter in its history. So to discuss the law violations of the past without focusing on criminal trials is how we can go forward. This is what one of my wonderful colleagues, Sam Bray, has called the past exonerative mode. We don't have to admit that what happened in the past was right, that there were wrongs, but we don't have to get into it in this kind of terms. We can talk about the future and how we avoid those same mistakes. We talk about the positives instead of attracting. We've got to start talking about, spend time on creating new ideas, new ways to attract people in without talking about holding people accountable, trying them for their crimes. After this style, there is substance. And the Compendium of Catholic Social Teaching is a forward-looking document of immense wisdom that can be a starting place. And I will now quote for you from Google AI on what Catholic social teaching has to say about this subject. CST strongly argues that human beings are capable of altruism, rooted in the belief that people are created in God's image with a natural capacity for love, solidarity, and self-gift. CST emphasizes that human motivation goes beyond self-interest to include concern for others and the common good. And in 10 seconds, which is 2 minutes past time, I will say, Pope Francis has said, and Pope Leo quoted him on January 9th, that we are not in an era of change. We are in a changed era. It is an era where fundamental, authentic law nevertheless endures, and where enduring law is our bedrock for the new structures and approaches needed for peace and the flourishing of all people and the natural world.
Thank you. There's a lot on the table now and some terrific framing remarks there. Just mindful of the clock, what I would suggest is not quite the 10 minutes we had in mind, but 5 minutes of just some chatter at the table. What resonated? What questions come to mind? What might you like to raise with the three panelists? And in 5 minutes or so, I'll open it up for at least a few questions before the reception. Some of us might come out and mingle, make our way to some of the tables, but 5 minutes for talking amongst yourselves. Our two co-organizers will be around to come to any table where there's a question for one, two, or all three of the panelists at this point, based upon your initial reflections. Do I have a hand from anyone who's right over here? You can start.
Hello, and thank you so much for this. As a member of Kathy's class this semester, I've been reading all of your works, all of you this week, and I'm looking forward to hearing more, and I love hearing from your own voices, the arguments made in the text. I have a question for Dr. O'Connell and Dr. Luban that's kind of two sides of the same coin, and that is, for you, Dr. Luban, where is the line where we might notice trusteeship failing? Yeah, because obviously the failure in the Trump administration is sort of almost insultingly crass in its in its shamelessness. It's hardly the fact that it emerged out of thin air, and we could point to very similar structure and development under the Biden administration, under the Obama administration, under the Bush administration, et cetera, of similar, though not to the quite quantitative extent, violations. Well, at what point do we find a line where we can say that's the trusteeship failing? We can see it beginning and can intervene, therefore, before we get to the point we've unfortunately reached. And the same question then sort of goes toward the natural law as well, Dr. O'Connell, because I think back to the world before Hobbes, the era that you're sort of defining as natural law era, and I still see a world that's sort of full of transactional violations, war, destruction, as you noted being sort of Hobbes' terrible inspiration, defended by fig leaf justifications, even to something like the natural law. So in what way can we begin to at least have some sort of certainty or guarantee that the natural law is not just a projection of ourselves written large in this era or any other? Thank you. You want to start? Okay.
Is this on? Yeah. Sorry about that. I mean, trusteeship fails all the time because, well, look, one possible criticism of the trusteeship model is that it kind of whitewashes the fact that we've never had law that didn't exclude a lot of people. That law has always favored the powerful and the wealthy, the majorities over the minorities. This is not just true in the United States, it's true everywhere. So I think of trusteeship as an ideal toward which lawyers ought to be dedicated rather than a descriptive claim about what we the people have actually done. I mean, we the people have our good moments and we have our bad moments. If you were my question would be, is it or maybe my way of rephrasing your question, is it a novelty that lawyers are active engines of trying to undermine the rule of law? I think it's not just the last couple of years, but I think that it's been at least since, 2015. Sometimes I think that the lawyers who are involved in the project, let me just backtrack for a moment. In 2015, there were a lot of American conservatives who were very nervous about Donald Trump as a possible candidate. And there was a famous article that was written anonymously or pseudonymously, published in the Claremont Review, which is a kind of highbrow journal of ideas, called The Flight 93 Election. And the allusion was to the passengers on 9/11 on Flight 93 who crashed the plane in order to save the Capitol. And Michael Anton, who wrote the article, said, this is the Flight 93 election. We have to bring down the plane if necessary. Now, there's a kind of apocalypticism there, but it was a sense of mission. I think that some of the lawyers who are attacking the rule of law and attacking democracy see themselves as Flight 93 lawyers. We are faced with a civilization, a culture that we hate. We think that it's undermining things that we believe in, and if the only way that we can stop that is by bringing down the rule of law or bringing down democracy, then so be it. I don't think that that's an attitude that's existed for more than, I don't know, 2 decades most.
Professor O'Connell?
Lots of different ways of answering your question, but I'll try to be as brief. I do want to point you to, there were 2 paths available at the time of Hobbes. His contemporary was a man named Hugo Grotius, known to be the father of international law. He was a scholastic. He was a follower of the Spanish scholastics and, of course, of Aquinas. And he wrote an enormous book that was looking forward to the end of the 30 Years' War, the horrible war of religion. It was a blueprint for how states could live together in peace, and it was based on the natural law and against war. And that was the dominant thinking in Western Europe as the modern state came into place. And there were no repeats of the 100 Years' War, the 30 Years' War, for a century until Napoleon. So you can look into thinking of, what undermined it at that point. But the founders of the United States, everyone, there was no theory of positive law alone without its framing in natural law until the middle of the 19th century. And then it's a very interesting story that I can't go into now about some of the reasons why Europeans, in particular to pursue colonialism, began to go out of their way in international legal theory, and that to undermine natural law. And of course that opened up these other ways of thinking, these materialist thinking that, well, of course, we're only doing this in our self-interest. We need law. We do have a tendency. I love the line from Iris Murdoch in her book, The Sovereignty of Good, that we need philosophy to keep us from becoming completely self-interested people. It's what draws us into selflessness. We need law for the same reason. We need them working together. We'll never have perfection in this world. I am very much hoping that I'm done enough in this life for the promises of Christ. I don't look for perfection here, but I do look for, to me, the biggest puzzle is, and what I've tried to work out with you today, is why did we let go of some of these ideas that we worked through the greatest hardships known to man, for simple, for piling up more weapons at extraordinary cost, spending $1 billion a day in Iran, and that we would try to think of law as only a way of only making sense of it maximizes wealth. So it's not that there's going to be perfection if we can understand the true authentic basis of law in natural law thinking, but I think we will not backslide as much as we have. I think our chance of doing better means returning to these ideas and really forward-looking, helping people understand them. It won't be easy. We haven't taught natural law, as I said, in an authentic way in this country since the 1960s. So it's really going to take work. But it's so much more positive, right? To think about that. I admire our colleagues who do law and economics. It's not easy. But in the end, it doesn't make sense. So to draw them out of it, and I think even at the University of Chicago, where I visited several times, they keep coming back to this idea, how do you explain fairness? They recognize fairness has to be part of the law, but it doesn't make sense in the marketplace. You do whatever you can, you take whatever shortcut to get ahead. So we're at a moment, I really do believe, Kathy and Greg were right to form this conference, to get these ideas going. So I'm not looking for perfection, but I don't want to fall backwards any farther than we have.
One more question over here.
Yeah, okay.
We were fired up by all three presentations. Thanks again. And the one that really got us going immediately was by Professor Mary Ellen O'Connell. So you're the target today. On the one hand, I think everyone in the room agrees that politically, legally, culturally, decline is not only pronounced, but it's accelerating. And we even see now the new theory with neo-royalism, about the few at the top who will take everything to themselves after the Middle Ages had collapsed and before we got the modern age. So whenever there's a cultural collapse, these things happen. So our question to you, given the situation that we are in, is what sort of natural law would you actually suggest we should be advancing? You mentioned John Finnis, but so quickly that one got the feeling that was perhaps not your favorite.
Thank you.
I'm a follower of Hugo Grotius. I think his understanding of natural law, which is directly from Aquinas, is the natural law we should be teaching again. We have modern exemplars of Grotius. I think the best contemporary teacher of this form of natural law was Alfred Verdross at the University of Vienna. He died in the 1980s. He did, at the end, maybe one of his last co-written pieces when he was quite senior, hedges a little too much, tries to get back into the fold because in his long debates with his teacher, Hans Kelsen, where he kept trying to get, Kelsen was a natural law scholar. And then he was told that wasn't scientific enough and he wanted to be taken seriously and remain, Roscoe Pound said he was the greatest legal theorist of the 20th century. Of course, it had to be the first half of the 20th century. But another natural lawyer, he doesn't develop it enough, but probably my greatest hero in all of international law is a man named Sir Hirsch Lauderpacht. He wrote an article in 1946 in which he saw the threat from realist thinking to natural law. He lost his whole family in the Holocaust, but he himself had risen to become the top international lawyer scholar in the world. He held the Hewell Professorship of Public International Law in Cambridge. And he wrote this beautiful article called The Grotian Tradition. And he called on people to believe in the law of love and to reject the law of selfishness. So I recommend Lauderpacht, and I'll hope to build on Lauderpacht going forward.
Before we wrap here, let me turn to you, Father Brennan. Is there anything based on the comments from your colleagues or that's been on your mind that you'd like to close with before we wrap?
I will get on a plane and go back to Australia knowing that your country is going through hell and therefore the world is too, but that there are people who are not only passionate but deeply intelligent and who have an intellectual commitment to finding a way forward. And it's that which gives us hope and puts us in touch with the transcendent. And I think it brings us back to Benedict's point. We're not here as church to find the solutions, but we are here to shine the light and to make sure that everything is on the table. So for that, I'm very grateful.
Thank you very much. That was a terrific set of commentaries to open 2 days of rich conversation. I ask you to join me in thanking the three panelists for a terrific open.